Welcome to another episode of Never Mind the Chaos. I'm Leonard Simpson, partner with 2020 Financial Advisors, joined by my co-host Michael Chastain of Chastain Jones Law. And it's our pleasure today to have as our guest attorney Robert Rediger of Rediger Labor Law. And Robert, you like going by Bob, correct?
That's fine.
Great. So, Bob, you've been in California quite a long time now in practice, but you actually started back in New York, correct? Is
Yes.
that where you came from?
Yeah, I
So
grew up in
tell
New
us how you
York.
got started.
Well, I went to college in New York, Queens College, and I was interested in law, so I took constitutional law, labor law class. Then when I got into law school in New York, I concentrated my studies in labor law and litigation. And then, the rest is history. I've been practicing labor and employment law on behalf of employers for the last 40 years.
You were in a
Bob,
partnership for about 9 years. Was that in New York?
no, it was out here. When I came to California, I joined a law firm, Hubbard and Shanley and Lee. I became a partner there. And then I went on to Cook, Brown, Rediger, and Prager for 10 years. Then from there, I started my own firm. It was Rediger and McHugh for a few years. And now it's Rediger Labor Law, where I practice with my three kids, all of whom are lawyers. And Ariel, Candace, and Justin are my three kids.
How did you end up coming out here?
I always liked the warmer climate, so I was admitted to the New York bar, and then my mom worked for the airlines, so I figured, okay, if I interview in Florida and California, I could always go back to New York if things don't work out. All my stuff
Yeah.
was flown out for free, and I got a good offer in California in Sacramento, so that's where I started practicing the same type of law that I had been doing in New York, which was representing management in labor matters.
So you had to
Okay.
take you had to come out here and take or come out to California and take the bar then.
Correct. So I'm admitted in two states.
Okay. Well, kudos to you because I never ever want to take another bar exam ever.
Or Bob, are you representing clients back in New York as well these days? Or
No, we represent employers. Some of them are very big. They have offices in New York, but most of my work is in California now. I'll do
okay.
collective bargaining negotiations and travel St. Louis. I've gone back to New York for an NLRB trial, but
Hmm.
95% of my work's in California.
Why law school? Tell us about that. What did you do as a young man, and what were your initial thoughts about your journey?
Um, I guess I made up my mind to go to law school when I was in college because I was taking different classes and I took constitutional law, labor law, and that kind of interested me. So I figured when I first got into college, I thought I might be an FBI agent. My
Is that
dad
right?
was a firefighter. He was talking to me
Okay.
about, that kind of work.
Yeah.
But one thing led to another, and it's like, okay, well, I might as well do something I enjoy. And fortunately, it worked out for me. And then once I got into law school, I was lucky too because there I got into an area of law that I enjoyed, which was labor law. A lot of my
Mhm.
friends had to take jobs in criminal law or divorce,
Right.
things like
Mhm.
that. And like I said, I was fortunate enough to get work at a management labor law firm, and that's what I've been doing for the last 40 years.
Okay. So you've always worked on the business side as opposed to the employee side.
Correct.
Interesting.
Yeah.
So
And
when if I understood it correctly, you joined a firm, you became a partner there. Why did that not apparently didn't work out, or you moved on to another partnership?
Yeah, basically you start working with other people and not everyone carries their weight, so to speak. And you start thinking, well, maybe there's other opportunities out there. And I always wanted to do labor and employment law on behalf of management. So other firms were talking to me and I decided to move on. Funny story though, I left my first job at Hubbard's law firm on Friday the 13th, the same day I moved into my house in Gold River. So they say the two most stressful things you can do is change jobs and change homes. I did them both on
yeah,
Friday the 13th.
Nice, nice. And so, do you
yeah.
live in Gold River still?
Yes.
Yeah, that's where we lived before we moved out here to New Mexico.
Hmm.
Gold River's a beautiful
Hmm. Very
place.
nice.
Oh, well, your office was in Gold River as well, Mike.
It was that was part of the reason why we lived there because so I could
Yeah.
walk to
Hmm.
work.
Yeah.
Hmm.
Yeah.
And the
Yeah.
fact that we had 7 redwood trees in the backyard, which is
Yeah.
a feature of Gold River that is really hard to find anywhere else.
Yeah.
Yeah.
Okay,
So, Bob, yeah.
I'm sorry, you leave Hubbard and you hook up with, it sounds like, four other, or three other, or four other guys, three other guys, I guess, three other people, and form a partnership. Tell us kind of how that manifested itself.
Well, what happened was that was Cook Brown. It was Cook Brown, and then there I became a partner too. So from Hubbard, I went to Cook Brown, Rediger, and Prager. And
Mhm.
same thing I was doing. There we had a partner who was in San Francisco. So we'd go there, and the firm got to be pretty big. And then that started imploding a little bit, and that broke apart. And that's when I decided to go out on my own. And I went out with my former partner, McHugh, and we started our own firm, and we went for about 20 years.
Okay. And
And were you able to
then
take
he
clients with you?
left.
I'm
I'm
sorry.
sorry. He
I was,
left. McHugh left.
Yes, it's a she woman.
Oh, she left. Okay.
And then that was about 5 years ago, and now it's been Rediger labor law where I practice with Ariel, Candace, and Justin.
Okay, interesting. So one of the things that we've talked about on this is the advantages and disadvantages of having partners. One of my mentors, when I went out on my own, I did not have a partner. One of my mentors said, never have partners ever.
Hmm.
I'm not sure that was the greatest advice, but I'm always curious as to your view on that now that you've done it basically both ways.
I think it's great to have partners, someone you can trust, someone you can rely upon. And all my kids now are partners. When I first started Rediger Labor Law, it was Candace Hanratty and me. That's her married name now. And
Mhm.
then I've made subsequently Ariel and Justin partners. So now the four of us are partners. And, it's a family business. We enjoy what we're doing, and we're contemplating, okay, do we expand or do we, keep it a family business? So things have been working out good, and like I mentioned, there's always someone suing their employers in California, so it's no lack of business,
Mm.
and it's just whether we want to take the firm. Now I'm on the cusp of retiring in a few years, so I might cut back part-time.
Bob, are there other associates in the firm or just the three
No,
kids?
just the four of us who are practicing attorneys.
Okay.
Then, of course, we
Well,
have my secretary, Lorraine, who's been with me
right,
for 35 years. And then I have my wife, Lori, doing the books now.
right.
Uh,
Yeah.
so,
Okay.
Well, it's interesting because most of the attorneys we've spoken to, they all seem the issue with the majority of them is this whole idea of succession planning, but you have a built-in succession plan,
mhm.
which is very unique.
Yeah, yeah.
Talk about the landscape of labor law in California as such, and are you seeing that uh, uh, changing in any way?
Well, it's changed over the years that I've been practicing. Originally, everything was the traditional labor law would be negotiating contracts with unions, going to the National Labor Relations Board. Then, after a decade, that sort of declined, and we saw an increase in the wrongful termination. So we found ourselves in court litigating wrongful termination, discrimination claims. Then, after a while, that came down. What we're seeing now are wage and hour claims. And
Mm,
what we used to settle for a few hundred or a few $1,000s, now these attorneys want everything to be a class action, or they bring these claims under the Private Attorney General's Act, PAGA. And out of the gate, they want six figures, seven figures, because they say our clients have a policy that affects not only their client but everyone. So they want to make everything a class action. And that's what we're seeing now, a big surge in these wage and hour class action PAGO lawsuits.
Can you give us an example of what it is that the claim is? Is it lack of break times or overtime, or what is it exactly?
Yeah, generally we get these letters in and then we get the complaints in, and they're almost like cookie cutter complaints. You didn't pay minimum wage. You didn't pay overtime. You didn't give the person at least a 30-minute meal period,
Hmm.
when they're working a full day, which has to be given before they work more than 5 hours. They're entitled to two paid rest periods during the day. And if you don't give those, there are certain premium pay requirements attached. 1 hour of pay for every missed meal period or rest break. So those are always included. Like I said, overtime's always alleged. Then they say, and the wage statements, the pay stubs aren't accurate because you didn't pay them correctly. So it becomes, stacking up the claims one after the other. And
Hmm.
then they try to get the judge to certify it as a class action. And if it is certified as a class action, you go from dealing with one employee to possibly the number that you have that are, that you're employing. So the stakes are high, and that's what we're seeing now.
Nice.
Virtually every month we get in a new lawsuit.
So
Um,
how
I'm
is
I'm
the
just curious because one of the things that we found and this is very anecdotal and a survey of one, but I found a lot of people didn't, especially in law firms, didn't want to take their breaks. You'd say, we'd have to like force them, hey, at noon you have to take a half hour, and sometimes we have to tell them to leave the office because otherwise they just simply wouldn't do it because they felt they had too much to do. Or is that a fairly common issue?
Yeah, it comes up quite a bit. And, we're really dealing with non-exempt employees. So professionals like lawyers don't have to take meal periods or rest breaks. But if
Right.
you're hourly paid, the law says that you're entitled to 10-minute rest breaks for every 4 hours or major fraction thereof. But the
Hmm.
law is a little bit more accommodating for employers in the area of rest periods. It says all an employer has to do is authorize and permit an employee to take a rest break. They can waive it. So as long as you have a good policy in place in that regard, you're okay. Meal periods are a little bit different. These have to be logged. So you have to keep adequate records of the person getting at least 30 minutes, and it has to be duty free. So, unfortunately, California treats the employees and the employers like little kids and tells them you have to take these meal periods, they have to be recorded. The defense from the employer's standpoint is, well, the person voluntarily waived it. They made a conscious decision not to take it. And that's usually where you get into fights over, did I really waive it or did you tell me work through it because I was too busy?
Okay. So
Bob?
what would your advice be, especially for smaller firms, right? We're not talking about like McDonald's and Jack in the Box, big employers, but small firms to protect themselves because the biggest issue for small firms, I think, is not that the cost of losing a suit, but to defend it.
Yeah, that's true. Not only that, if you lose, not only are you paying your defense attorney, then you're paying the disgruntled employee. Then the disgruntled employee says, here's my bill for legal fees as well. So you
Mhm.
lose three ways. Excuse me. Certain things I would suggest is start with good hiring. Make sure that you avoid the problem by bringing in only good people.
Mhm.
And if you're, hiring, make sure the person completes your employment application, all of your questions. It's a red flag if they submit a resume and say, "See attached." That means they don't want to answer your questions. They just want to be hired. And chances
Mhm.
are they've sued other employers in the past. So, you try to bring in good people so you don't have the problem in the first place. Number two, have good policies. Every employee handbook I review has some mistakes in there. So
Mhm.
again, if I'm a plaintiff's attorney, I'm looking for an illegal policy that applies to everyone. Now you're potentially running a class action. You're giving me a class action to sue you. So make sure
So,
your policies comply with the law.
so let me just ask you more specifically about that. Um, every employer should have a written employee handbook. You agree with that?
Yes.
Is there, so, I'm a small firm owner. I don't really know what to do. How does one get a good written handbook that they can, maybe download off the web or at least use as a template to get started.
Yeah, well, chances are they have some policies in writing. They have something, an offer letter that they've given the employee laying out, these are our terms and conditions of employment. Here are your benefits. Here's your wages.
Hmm.
There are certain forms you have to give the employee. It's called notice of employee right at the beginning. And it has some policies in there. It references sick leave, who the workers' comp carrier is, what your wage rate is, how overtime's computed. So they're kind of already down that path. So now you just have to talk to a labor lawyer or a management consultant, or even go online and get an idea of the types of policies you might want to have in place. But the key is you got to make sure your policies conform with the law. So you couldn't say, yeah, I give meal periods, take it whenever you want. Your policy has to track what's in the wage orders. So that's what I would tell someone that doesn't have an employee policy in place to do. See what you want to do, get some ideas, and then make sure that they conform to the law. That's the big key.
Bob, how does an employer manage this? And I have to believe maybe it's not intentional on the part of the employer, but if you have a number of employees in multiple locations, you might have this spelled out in a handbook, but how do you manage to employees that are not taking a lunch break?
Well, if worse comes to worse, you have to discipline them. Here's our policy. You have to record that you've taken these meal periods. If you're not taking them, now the law says I have to pay you 1 hour of premium pay. So what's the problem? Are you being insubordinate? Because I'm telling you to do it. If you want to waive it, you're creating a potential problem for both of us. Because things work out fine as long as everyone's getting along, but then the employee gets disciplined or terminated, and all of a sudden the story changes, and it's like you didn't give me my meal period. Um,
So
you know,
there's a mechanism in place where employees have to record actually taking the break, taking a lunch break.
yes, on
That's the
your
expectation.
time card, it has to have
On your,
in for the day,
I
out for
see.
the meal period, back from the meal period, and leaving for the day. So it has to be 4 entries on a time card each day the
I
employee works.
see. Okay. And I suspect that doesn't go on with a lot of employers, maybe because they don't really know.
That's right. Or else, like you said, they're too busy. No one's filling it in
Right.
correctly. A lot of employers are moving to an electronic punch
Right.
card, and they're
Mhm.
doing it that way. But you have to have some mechanism in place to ensure that you have good records, because if you're going to be sued, the first thing the plaintiff's attorney asks for is, let me
Mm.
see your payroll records. And if you're not keeping records, then they want to know, okay, now is it company wide? Because now we're looking at potential class action. People
Interesting.
aren't getting
How are employers getting educated on this?
how's who getting?
How are employers getting educated on this, if
Usually they
any?
get sued.
That's when they
That's how they find out.
They learned the hard way.
Yeah.
learn the hard way.
Yeah.
What, just out of curiosity, how long should an employer keep those records? I mean, how far
Um,
back can a employee go and say, uh, I worked there 5 years ago and now I'm suing? What is there a statute of limitations for them to
well,
sue?
the labor code says they can go back 3 years, but a smart plaintiff's attorney sues under the UCL. It's called the unfair competition law, and that has a 4 year statute of limitations. So technically, they can go back 4 years. So when we get these lawsuits filed, the plaintiff's attorney always asks for documentation that goes back 4 years from the date of filing.
From the
So,
date
Bob,
of the filing?
are you saying in terms of the companies that you're representing, are these tend to be larger companies with multiple locations? What are you seeing out there in terms of the employers that are getting into trouble with
Well,
this?
basically, if you're a successful employer, you'll eventually get sued. It's unfortunate a lot of these lawsuits come out of Los Angeles, and many firms representing plaintiffs just send out these letters to every employer.
I
And
see.
they say,
Okay.
okay, my guy didn't get meal periods, rest breaks, and you get the boilerplate letter. And it's not true. These are just allegations they're making.
Mhm.
So they go after small employers, and they go after Fortune 500 companies. Now, once you go out of the state of California, the rules are different because every state has their own rules. But if they have branches in California, you figure, okay, how many employees do we have? That's how many employees that the plaintiff's attorney is going to say they didn't get their meal periods or rest breaks. Now, they'll take out the managers, but the rank and file non-exempt employees, they'll try to include in the class.
So if I had uh, remote workers, so let's say, okay, my firm's in, or my business is in California, but I got people working in New Mexico and Utah and Wyoming or whatever. What laws apply to those remote workers?
Well, that's where they're working. So the law of where they're working would apply. If they're based in California, then they're covered by California law. But if you're just having someone in New York do some work for you and they email it or they, use the computer to send it, they're going to be covered by the New York laws.
Okay, so as an example, I mean, lawyers are exempt from a lot of these things, so they're not going to matter. But
Mhm.
I've got a firm in California. We're based out of California, but we've got workers in just say New Mexico. I got some lawyers and I got staff that would be not, non-exempt, right? I got a secretary, I got a paralegal or whatever. Would the laws of New Mexico still cover them, even though everything is coming out of California and they're just um,
Well, I don't know. I'd have to do a little research on that because,
okay.
the test is, do they have enough contacts with California? Then you look into, okay, is your contract here? Did you execute it in California? Then there are additional rules if arbitration is involved. So, it's very fact sensitive. And to give a definitive answer, I'd have to look at the specifics of the case and then, do a little legal research.
Okay, so for employers, I mean, because more and more people are going completely remote. I mean, we talked to a lawyer
Mhm.
last week, and his entire firm is remote. He doesn't even have an office. But those are the questions that one should be asking: is what laws are actually going to be in effect for
Mhm.
my remote workers?
Sure. And California is always usually the most employee friendly and protective. So if you're following California laws, chances are you're satisfying laws in other states. But that was a big issue a few years ago when COVID hit. And people were saying, well, now do I have to pay that employee's expenses? Because they're having to dig into their own pocket to use their own computer and electricity and things like that. What about meal periods and rest breaks? How do I track that? The person's working at home. How about if they fall down in their house while they're on the clock? So all those kinds of issues came up for remote working.
Were those issues dealt with in any way by the legislature or just by case law, or how is that kind of getting resolved?
Not by the legislature. I guess it would have come up in the Workers' Comp Appeals Board or unemployment EDD, the Employment Development Department. So there are cases out there that have dealt with those issues, but I can't think of any court cases that have dealt specifically with it. Of course, you have your statute, Labor Code 2805, I think it is, dealing with the employer's duty to reimburse for expenses. So that comes up a lot where the employee says, okay, you're going to have to pay me, the cost for me to operate at home. How
Right.
much do I have to take out of my own pocket? So, employers should have a good reimbursement policy that complies with the labor code in that regard.
Sure. So that would be the like things like your computer, your Wi-Fi,
Yeah.
whatever, paper for your printer. I mean, all that.
Correct. Correct. There is a case dealing with cell phones where if you require employees to use their cell phones for work, you have to reimburse them for that.
So I saw the other day, and I don't know if this passed somewhere, but there was a thing about. I mean, one of the big concerns about remote workers is they're basically on call 24/7, right? Is if their phone works, you know, people expect them to answer the phone. And I read something about a law saying that, they can turn it off and not answer the phone and their employer can't, punish them in any way.
Yeah, that wouldn't apply just to remote workers. That was a law that was intended to apply to all employees, basically saying if they're off duty, you shouldn't be calling them. And
Mhm.
I don't think it's a law. It was just a proposal. I don't think it
Okay.
passed.
Okay. Um,
But so many employees call up or need to know their schedule or things like that. So I've had quite a few cases like that where the employees say, yeah, people would call me, ask me how to do things on my off time. Well,
mhm.
did you submit payment? Did you request payment for that? No. Well, how are people supposed to know? So,
Okay.
but
So,
technically,
Bob,
if
are
you're
you?
asking the person to work outside their hours, they could put in for the time. It's
Right.
probably going to be overtime.
So would you recommend that that be part of the employee manual of kind of how to deal with when you're not working? And if,
Mhm.
you know, the building's on fire, right? There, there's an emergency and they need to call you, how you address that and get reimbursed or paid for your time.
Well, yeah, you should have policies saying, only work the hours you're scheduled to work. Do not work overtime unless you're specifically directed by your manager to do so. And here's our reimbursement policy. If you believe you're entitled to be reimbursed for something, submit the form, complete it, submit receipts, and you'll be reimbursed. And if you believe you're entitled to overtime, you got to let us know. Put it on your time card. What I tell my clients to do is have a time card that tells the employee sign it. You're acknowledging that all the information on here is correct. Also, on the back of the time card, put the meal period and rest break rules, and then have the employee note, I missed a meal period or rest break on this day. So at least you've put in place some safeguards to help you to avoid the claim where the guy says, I never got a meal period, I never got a rest break, and that's how you treat everyone. Give me $1 million.
Right. So do you
Bob, do
recommend
you?
people using, I'm sorry, recommending using, pen and paper or electronic, or does it matter?
No, it doesn't matter. Just as long as you have a good system that tells employees what the rules are and makes them acknowledge this is the information I'm putting in and it's true and correct. And if there's a problem, if the person legitimately missed a meal period or rest break, make sure you pay them the 1 hour premium pay.
Bob, from your experience, do you think that one of the reasons why employers end up, uh, getting in trouble with these labor laws is because some of them, particularly some of the smaller employers, don't even have a competent HR person? Because
Uh,
doesn't a lot of it have to do with really having a good HR person that's going to put these, uh, you know, employee handbooks together? I would
yes,
imagine that's really important.
yeah, it is important to have a good, competent HR person. One of the problems I've found sometimes is HR causes the problem. They tend to reword things and put extra words in. Next thing you know, they've changed the legal standards. So I always tell the HR people, number one, your policy should track the language of the law as best you can. Don't put extra stuff in or take things out. And number two, if you have any questions, give me a call. HR is wrong sometimes with what they
Mhm.
do, but the answer to your question is yes, that's very important to have someone that knows what's going on, especially when it comes to leaves of absences. There's
Mhm.
like 20 different reasons employees can be excused from their job. So the HR person or the supervisor might say, no, you can't have off for that. Next thing you know, you're in violation of the jury duty law or, Family Medical Leave Act or something. So you have to have an HR person that knows that area alone, which is very complicated.
What
Do
is
you?
your thought on these outsourced HR, like, Bambi and those kind of companies? I mean, you got a small firm, you got, maybe two lawyers and a couple staff. You can't afford a full-time HR person. So what's your thought about that?
I, for the life of me, do not know how they offer HR services for $99 a month. I don't know how they can do it because, there's so many different things that could come up. I guess for a small firm that has one or two employees, that's fine because you're not going to hire an HR person for that.
Right.
But in terms of a big company, I don't know how these people can advise employers, okay, let's deal with the sexual harassment case in this way, or let's deal with this wrongful termination claim or this wage and hour claim for $99 a month. I just don't know how they can do it because it's so time consuming. When clients call me with those issues, the first thing I want to see is let me look at the personnel file. Let me see what records you have. What policies do you have in place? So
Right.
it takes a while to be able to see what's going on so you can advise the client. So I don't know how these other services do it for such a low rate.
Yeah, I
And
wonder
how
if
do
they
they
use
do it
the
when they're
well, I was gonna say, I just wonder if they use the sort of the gym uh uh idea that, you open a gym, you offer super low rates, and you figure that most people won't ever show up. So
Maybe.
you figure people won't call and you can make it work. Because I mean, those firms exist. I've never used one, but I'm trying to think of what good advice you can give to small businesses that, can't afford a $70,000 full-time HR person and frankly don't need that much monitoring.
Well, on the cheap, the only thing you can do is go to the official websites. For example, the Labor Commissioner website, the Department of Fair Employment and Housing, which is now called the Civil Rights Department. They all have websites that you can go to. And if you spend the time looking at it, you can get some information. For example, the Civil Rights Department has a whole section on anti-harassment training that employers can access. So there are free resources out there. You just have to know where to go, and then you can educate yourself, or you get a competent labor attorney and you just call them periodically to make sure you're on the right path, especially when you're confronted with something out of the ordinary.
Bob, I'm
Interesting.
curious, are there seminars out there, workshops to speak to this topic to employers? And is that something, if there are, have you had an opportunity to teach or speak at?
Oh yeah, I've given a lot of those for NBI and National Business Institute and others. They're
Hmm.
always offering different programs. Usually it's an hour or so, and it's on different topics. I've done them on leaves of absences,
Hmm.
what to do if a union tries organizing you. There's all different ones out there. Usually a few $100s. A lot of times you can take them remotely over over the computer.
Okay.
Interesting. So
I,
you told us during the pre-interview a little bit about having an issue with the receptionist that embezzled from you. Uh,
Yeah,
can you tell us a little bit about how that happened and how did you discover it?
well, generally, we had this receptionist who worked for us for about 10 years, and it was like her first job out of high school. And you just tend to start trusting someone. And one of my partners once said to me, Bob, it's not a good idea that you have the same person open the mail and do the reports and deposit your checks. And my famous words were, if I can't trust Sarah, who can I trust?
Right.
And I'm in San Francisco doing collective bargaining negotiations. And I get a call from some lawyer. He says, Sarah's not coming to work anymore, Bob. She embezzled $100,000 from you. It's like, holy moly, what's going on? So we go back, we continue doing our audit, and she had a few little kids, and we weren't going to put her in jail. So her parents wound up giving us $100,000 back, hoping that that would be the end of it. Next thing you know, our our financial person who's doing the audit says it's not 100,000, it's more like 500,000.
Wow.
So I guess the parents at that point were lied to, and they weren't going to give us another 400K, so they throw her under the bus. And we filed a police report, and the police said you'd not believe how often this happens to lawyers because no one's paying attention to the finances. You're all practicing law. So they said, given the amount involved, we're going to hand this over to the feds. So then the FBI comes in, they took over the case. They actually filed a federal indictment against her, and we were in federal court. She went to federal prison for 2 years.
Wow.
how was she embezzling the money,
Yeah, had
Bob?
two sets of books. One she showed us, and one to take money to go gambling at Red Hawk Casino. So I always joke that's the Red Hawk Casino Rediger labor law wing there that built that.
Wow.
You
So
were out 400,000, sounds like.
Yeah, yeah.
yeah, so what would your advice to I mean, because it sounds like what happened, which is fairly typical with law firms, is you're busy practicing law. and you're just trusting your people to do the thing. So, what safeguards would you recommend businesses put in place to avoid, so they could trust but verify that the right money is going in the right place?
Well, ask questions and have your accountants do an audit. That's one of the things we could have done. It's extra cost, of course, but you have the accountant do a thorough job every year. And, like I said, start hiring with the good people to begin with, and hopefully you won't have a bad person. But in my case, it was, someone we trusted. It was 10 years she worked for us. Who would have
Mm.
thought? So they see all this money coming in. They figure, oh, they're not going to miss 10,000. They get away with that. Next thing you know, it's, 100,000.
Right. I mean, one of the
Oh.
things that we've done in our office is, and I think you alluded to it, is different people have different roles, and they have to double check with each other. So all
Hmm.
the money that comes in goes through one person, but we have a separate bookkeeper. And if those numbers are off, uh, and the other thing that I've always felt kept us honest is that all of the money communication was emailed back and forth, and I got a copy of it. I got CC'd on every transaction, so that I didn't look at all of them, to be honest, but I
Hmm.
looked at enough of them to know what was going on. And then the third thing is that I looked at the P&L
Hmm.
regularly, and so if the numbers didn't look right, then I could start digging.
Yeah.
So.
Yeah, that's good. That's good advice, Mike. Always double check it. Always look at, what you can. Um, one of the things that was a, a warning sign to us that we really didn't catch on is we were paying taxes on phantom income. How come we're paying more tax on money than we put in our pocket? The reason was she was taking the money, putting it in her pocket. So
Hmm.
the clients were still reporting to the IRS they paid us, and it looked like we were getting more money than we actually got.
Interesting. Yeah.
So what steps did you implement after that? How did you
Had my
address that?
wife,
What changes did
I put
what's
my
that?
wife in as the
You
bookkeeper,
put your
so
wife.
she's doing it now.
Okay. That
Interesting.
makes a big difference.
Mhm.
So I'm assuming that was a somewhat of a setback financially to
No, no, it's
no?
unfortunate that what went on, but none of us caught it. And, it was just over time,
Over
probably
time. Okay.
over, 5 years. That's how far we went back in the audit.
Hmm.
And she probably took like 100,000 a year.
Wow.
It's incredible. What an incredible story.
Yeah.
Yeah.
Yeah, it's a shame, but that's what goes on in the real world.
Yeah.
Are,
Yeah.
are
I
you
mean,
seeing more activity now in with respect to litigation? You mentioned that there's a lot of class action
Hmm.
lawsuits. Have you seen that grow,
Yes.
expand?
Yeah,
And
yeah,
so so
tremendously.
what's driving that, Bob? What do you think is
Money.
driving it?
Money,
Money.
like I said, out of the gate, these plaintiffs' attorneys are looking for six figures. They all want to go to mediation right away, and they want to try to settle the case, and they want you to assume that it would be a class action. So they're
Okay.
always looking for, okay, let's talk a few $100,000, and that's what I'm seeing now. A lot of money at stake.
I mean, I know every case, lives and dies on its own merits, but as a general rule, are the ones that you feel are not meritorious, are they getting tossed out, or are people still recovering because it's cheaper to pay them than it is to litigate it?
Yeah, the latter. I just settled a class action lawsuit in Placer County for around 200K. And my client says he was talking with his friends in Los Angeles, and they said anytime you can get rid of one of these class action PAGA lawsuits for under 500K, you're doing good. So
Wow.
a lot of employers say, okay, if I lose, like I said, I got to pay you, I got to pay plaintiff, I got to pay the class, I got to pay the plaintiff's attorney, plus I'm in litigation for 4 years. So let's try to cut a deal early on.
So does any of that does the state get involved in any of that
The state gets
that
involved from the standpoint of collecting money. For example, if a lawsuit's brought under the Private Attorney General's Act, PAGA, the state is supposed to get 75% of the proceeds after the lawyer takes his cut. So that was recently changed. It's going to be 65% with the employees getting 35. But right now it's state gets 75% and the employees get 25.
What's the justification for that? I mean, if the employee's
Exactly.
actually
Yeah.
been ripped off, or is it because it's class action that each employee is not going to get very much anyway?
Well, yeah, that too, but also in terms of the PAGA lawsuit, the Private Attorney General's Act, that's how the law is written. That
Mhm.
basically the state is saying the Labor Commissioner's office is too busy, so we're going to deputize you as an agent of the state so you can bring this lawsuit and then give us 75%. And, the lawyers take their fee out first, then the
Mhm.
remaining amount of money is split 75-25. So those are in PAGA lawsuits. That's how the law is set up to be.
So is that
Oh,
why every once in a while I get a notice, oh, there was a class action you were part of, and call us if you want your 75 cents.
Well, class actions are a little bit different. The state's not involved in class actions.
Okay.
Sometimes plaintiffs' attorneys file two lawsuits, one class action, one PAGA lawsuit. You got two lawsuits, same parties. Who
Hmm.
knows why they do that? But anyway, class actions are a little bit different because you don't have to give the state any money. That's
Okay.
just between the attorney and the plaintiffs. But it has to
Interesting.
be
the 65.
supervised by a judge, and a judge has to sign off
Hmm.
on the final settlement.
Hmm.
Where's that money go to, the 65%? Does that go to the general fund? Where do,
Who
what,
knows? Goes to the state somewhere. Who knows where it goes? But they bring in a lot of money. And there are some law firms that specialize in just bringing these PAGA lawsuits. I mean, there's websites, and you can see, and the same 10 firms bring them
Hmm.
against every employer.
wow,
Interesting.
wasn't aware of that.
Yeah. Yeah, we deal with several of them now. And
Okay.
they'll even tell us, they'll say, the law was made to help the attorneys, not the
Not,
employees.
yeah,
Sort
Right.
of a shame.
it is a shame.
So, part of what the purpose of this podcast is to help, law firm owners and other attorneys, make decisions about, should I open a firm? Should I close a firm? What should I do? From your perspective and doing the kind of work that you do, what would be the, maybe top two or three pieces of advice you would give someone who's either got a firm and they need to get their ducks in order or thinking about opening up a firm?
Well, again, I started listing some of the things I would suggest to avoid potential litigation. Because if you're successful, it's only a matter of time before some plaintiff's attorney says you're doing something wrong, give me some of your money. So you make sure you hire good people, you have good policies in place, post all your notices. There's like 20 different notices between the federal and state government you're supposed to post informing employees of their rights.
Hmm.
Conduct the training that's necessary. The law says you have to have your supervisors submit to anti-harassment training every 2 years. Employees now do it every year, I think. So you do your training. Also have well-written job descriptions. Tell people what you expect of them. Put things in writing. Here's the offer letter spelling out, the terms and conditions of your employment. And if you're going to discipline someone, make sure you discipline them. Always have legitimate business reasons for your actions. So if they say, I was disciplined or fired inappropriately, you say not only were you an at-will employee and we could let you go, but also here's our legitimate business reasons. So if they're alleging some type of discrimination claim, you can always say, okay, I had these reasons, they were put on notice, they didn't conform, they're in violation of our policies, so the termination was solid. So should employers or should companies start up their own business? Well, yeah, it's always great to have your own business. You just have to make sure when you're hiring employees, you gotta be careful how you do it to make sure that you're not on the receiving end of one of these lawsuits I was talking about.
Okay. So to kind of summarize that, good written policies, right? Or oral policies probably don't pull much weight. Would that be
Right,
right?
because it's always like, that's not what you said, or I misunderstood it, or they
Right.
intentionally misunderstand it.
So taking the time to have good written policies, document. So if you're going to let somebody go, I was always taught and believe that, you need to start documenting the reasons why you're going to let that person go and not leave it to the last minute, but contemporaneously start documenting the problems.
Very good advice. During the 80s, employers would always call me up and say, hey, I got the worst employee in the world. I want to fire him. And then I'd look at the personnel file, glowing reviews, no, bad evaluations or anything like that. So yeah, it's good to document, but you got to do it honestly and you got to do it timely. So if the person needs to be disciplined or written up or the corrections, constructive criticism, don't be afraid to do it. Truth is always the best defense.
Right. Well, that's some really great advice. Thanks so
Yeah.
much, Bob. And it's really truly been a pleasure visiting with you this morning.
Same here, guys. Thank you very much.
All right.
Thank you.
Thanks, Bob. Appreciate it.
Bye.
Sunrise and the early bird brought me to my senses. It's a chilly wind this morning, not a cloud in the sky. Today I walk the ancient trails among the petroglyphs and cactus, and I hope